when it comes to unpacking this topic, and basically to share a few objectives before we hand over to Natasha. Mr. Lungisani will also come in at some point to kind of reiterate on this on the part of Laz. But the objectives of this webinar are to, one, evaluate the current levels of engagement of Zambian lawyers and law firms with international dispute resolution mechanisms, to outline the importance of integrating traditional dispute resolution mechanisms with human rights principles and international practices, and to provide a preliminary understanding of existing international dispute resolution mechanisms. So this whole activity, which is going to be part of a series we'll be rolling out, is essentially intended to merge business with human rights, because there's been an evaluation that not many lawyers are engaging. Not many lawyers at the Zambian bar really understand how to engage with human rights mechanisms, don't really fully understand what human rights is. So the point is to have an expansion of the business of law, which kind of incorporates both business and corporate practices with human rights practices, and also to understand that there is essentially life beyond the Supreme Court. So what happens when, we say when you go to the Supreme Court in law school, we are taught that that's it. So once the Supreme Court makes a pronouncement on something, you have no further recourse. But then what happens beyond, what exists beyond the borders of our jurisdiction? That's something that we also want to kind of unpack today. So on that note, I will hand over to Mrs. Natasha Museva to give us our first session on placing human rights in international practice and navigating global barriers. Over to you.
Thank you, Mayor. I thought the president was opening us up, but happy to go ahead. Can you confirm?
Yes, unfortunately he will be joining us. I can't see him on the call right now, but he says he will join at some point.
Hi, Mayor. I'm actually here. Sorry.
Great. Awesome. So I think we'll hand over to you just quickly, maybe to give us some remarks before we proceed. Thank you.
Thank you, Mia, and my apologies. I'm in the field, as you had indicated, so my network is a bit shaky, but I couldn't miss the webinar for anything because the webinar is very important in discussing internationalization of legal practice. And for us as the Zambian bar, it is high time that we discussed and looked for ways in which we can expand the practice of the law beyond the Zambian boundaries. As you recall, we are off the African Continental Free Trade Area Agreement. We are just in the discussion points in terms of how can we make Africa borderless, how can we ensure that goods and services can cross Africa freely from Zambia to South Africa without tariffs and customs that are prohibitive. And there's no better positioned service provider than the legal profession. And it is important for us to contextualize our discussion in those parameters. The businesses are increasingly looking for ways in which they can, expand their reach, expand their markets, but not just the business. Human rights is taking an international outlook, and it is important for citizens everywhere to be able to actualize the basic human rights. There are a number of international fora where human rights related activism and litigation is discussed as well as litigated. But it is the lawyers from Zambia who must not be out of the discussion. We must also be able to be part of the contribution of internationalizing human rights and enjoyment of human rights by everyone and not just Zambians. So I thought it is important for us to, one, bring a number of stakeholders on board who can help us to build capacity to be able to do more in internationalizing our practice. For a long time, Zambia has been a key stakeholder in international agreements, uh, both business side as well as human rights related. But the legal profession must take a leading role in ensuring that our profile as a country is indeed aligned with our aspirations in those international human rights and business related agreements. So ultimately, the idea is beginning so that indeed, as you indicated, Mia, it is possible to practice as a Zambian completely out of the country. The world is becoming a global village, and we must be key players in that village insofar as access to justice and facilitation of business is concerned. And I'm excited that the very eminent team of panelists has been assembled to help us in walking this journey, which I am very, very clear in my mind will be very exciting. So I'm happy to be part of this workshop and to open a door and a window for Zambian law firms and Zambian lawyers to begin internationalizing their legal practice. I look forward to hearing the various perspectives from our eminent panelists and fruitful discussions with the audience. And with that, I'm happy to formally open the webinar.
Thank you so much, Mr. Zulu, for that. It really lays a great foundation for this discussion. And I think because I've already given a brief introduction, I think I can quickly hand over to Natasha to take the floor. Thank you.
Thank you, Mayor. It's a great honor to be on this call, to be on the webinar, and to all my learned colleagues on the call. Thank you for making the time to listen to us, to follow this topic, which is a broad topic. I am delighted to speak today. So to start with, I think, first of all, that it's a broad topic, the internationalization of legal practice. But as Mayor and the President have mentioned, so Mr. Zulu, we are just trying to outline here the fact that the world has become a global village. This is a discussion we've had for a long time, and many of us are interacting quite often with a lot of international legal instruments that impact our work directly. I think I started my practice off in the corporate world. So I worked for corpus legal practitioners in the beginning of my practice. And then I moved on to the Ministry of Justice, where I worked in the Department of International Law and Agreements. So I have a master's degree in international human rights law. So I have interacted very consistently and many times with the human rights legal instruments, but I am now practicing environmental law. So I'm in the sustainability space where I consult with the United Nations on climate change and plastic pollution. So I hope that as I share this information, which of course is, I know many of us have broad aspects that we know about international law, I will narrow it down to three main topics. The first being the human rights space. What do we have there? What are we dealing with in that space that is relevant to the work we do, whether it is in the corporate world or otherwise? And then I will go into the environmental issues, the international legal framework for environmental law, briefly touching only on climate change and plastic pollution, and then generally ESG, so environmental social governance. What is the responsibility that businesses have in this space, and where do we as lawyers practicing in Zambia have to keep our eyes open to understand how the work that we do engages with the international space? So I will try and make this very short so that we could have more time to interact. And I'll just start with a brief background. Many of us may already know this, but traditional international law was mostly related to the relations among states. If today you Googled what is international law, the simple answer you'll get is that it's the system and principles that govern relations among states. But this has become broader over time in the sense that on the human rights dimension, individuals have started to play a key role in international law. We have a lot of international principles and systems that are developed in the trade space. Of course, there is diplomacy and the environment. These are the 4 areas that I will focus my discussion on. And of course, we know that ultimately the idea is that international law is meant to protect people, the environment, and relations among states. So the evolution has happened over the time that we know that the world wars had initially started off. So we had simple mechanisms like the Nuremberg trials. We had the UN Charter established after that. We had the UDHR. I will say these in full: United Nations Declaration on Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. And then as an example, we also had the evolution of the genocide in Rwanda. And so the International Criminal Tribunal that was established, and many of us may have followed this quite well. And we understand that a mechanism was established to adjudicate the violations of human rights, and there was accountability established in relation to those responsible for mass killings and crimes against humanity. We also have key instruments such as the Convention on Elimination of Discrimination Against Women, the Convention Against Torture, and the Convention on the Rights of Children. There are many more, but I would like to focus the discussion. So I'm just going to go straight into the juridical systems that exist, especially, firstly, on human rights. So the first mechanism that we have at continental level is what is called the African Court of Justice and Human Rights. Now, the African Court of Justice and Human Rights has evolved in the sense that it started off as the African Court on Human and People's Rights, and then there was established the African Court of Justice, and the AU decided that we just have to have one mechanism for dispute resolution at the continental level as far as human rights is concerned. And so it established the African Court of Justice. So it's a merger of these 2. Now, there are a few challenges that we have in relation to the African Court of Justice and Human Rights, because in international law generally, I know we may all know this, for an international instrument to be binding at national level or for it to actually enter into force, there have to be a certain number of ratifications. And depending on what type of law the state has, to domesticate, you need an actual existing piece of legislation to adopt the provisions of that instrument. So with the African Court of Justice and Human Rights, we do not have sufficient ratifications in place. So what that means is that currently, individuals or NGOs that have claims that they would like to take to the African Court on Human Rights have to take these through the African Commission, because the standing before the African Court on Human Rights is only in relation to states as well as the Commission. So when individuals or NGOs have any complaints on human rights, they have to take these through the Commission and cannot appear directly before the African Court. So this is the first challenge that we have in this mechanism of justice that is established at continental level. And if an individual intends to take a matter before the African Court of Human Rights, there is a requirement that the state to which they belong must have signed a special declaration under the protocol enabling individuals to take matters directly to the African Court on Human Rights. So if a matter had to be taken by an individual or an NGO, there is this restriction that exists. So that's the first challenge we have. However, it is a mechanism available and open to individual states or NGOs, which has to go through the Commission. At international level, we have the International Court of Justice. However, the International Court of Justice also has its limitations because it settles disputes between states. So within the overall UN system, if there are any provisions, if there are any disputes relating to territorial disputes, border issues, ideally these would go before the International Court of Justice. Individuals cannot take a matter directly, but the United Nations Security Council has standing before the International Court of Justice, which is to request for an advisory opinion. The last mechanism is the International Criminal Court, which prosecutes individuals for crimes like genocide and war crimes or crimes against humanity. There is also a restriction here on who can take a matter before the ICC, and this is, of course, its member states or the ICC prosecutor. Now, I'm highlighting these because many of us have probably interacted, especially those in the human rights space, those that work directly with NGOs, whether it's with the criminal justice system. And we do notice that there is an increase in human rights violations that end at our constitutional court level. And maybe if there was ever a time that an NGO approached a government institution or a law firm wanting to take a matter before the African Court or before the ICC, these are some of the avenues that we could refer them to, but these are very, very focused on human rights violations. Now, the second approach is on the environmental space, which is where I'd like to share a bit more of what I think is developing now and which affects most of our work as lawyers in Zambia. So there is a growing compliance mechanism now on legal and ethical obligations which businesses have to comply with. And this is to prevent, minimize, and remediate environmental damage caused by their operations. So now, for instance, if a client came to a law firm and wanted to enter into a large investment project, whether it's construction, energy, mining, or otherwise, it is a prerequisite that this entity must conduct, first of all, an environmental impact assessment. Now, this arises because there, for instance, in the African Charter, in Article 24, there is a provision on environmental rights. What that means is that if there are any practices that businesses are conducting that have a direct impact on the ecosystems or the life and livelihood and health of people in the country, then there is an obligation on the state to ensure that the businesses conduct their dealings or any other activities in line with required environmental standards. So many of us may know this. Almost every country now has developed an Environmental Management Act, or under the energy laws, there are environmental requirements. All of this has evolved because businesses no longer conduct business as usual. There are restrictions on how they should conduct business. Now, many of us are probably aware of the Paris Agreement and the United Nations Framework Convention on Climate Change. This one is specifically focused on reduction of GHG emissions. So this is greenhouse gas emissions. So the basic concept is that businesses must ensure that as they conduct business, they are focused on mitigating or adapting to climate requirements. So you cannot now just commence an industrialization project without taking into account how much greenhouse gases will be emitted into the environment. But beyond the climate change instruments, we also have instruments such as the Basel Convention, which regulates hazardous waste disposal and transboundary movements. We have the Stockholm Convention, which controls the use of harmful chemicals and pollutants. And we have the UN Guiding Principles on Business and Human Rights. These guiding principles set out corporate responsibility to protect the environment. So whenever clients come before us with these large projects, we should not only speak to them about the fact that they have to focus on net zero, which is reducing greenhouse gas emissions, but we should also understand from the context and nature of the work, what impact it will have on production of chemicals, for instance, if that is the nature that the business is conducting. We also have the space around waste management. And of course, there's environmental laws at country level that regulate what type of projects companies can conduct. well, not about what they can conduct, but what they can do in that space that is relevant to protecting the environment. So we have the Environmental Management Act in Zambia, we have the Solid Waste Management Act, we have the energy regulation laws. All of these, you will notice, have now set up key caps and regulations around what needs to be done through feasibility studies, environmental impact assessments, the standard for corporate social responsibility. All of this goes beyond just our national laws, but is in the overall international plan to protect the environment. So we need to be more cautious as we interact with corporate clients, including banks, because banks, of course, release funds for projects that are broader than we know could just be in the production industry, manufacturing industry, mining, and energy. So sustainable financing has become a concept that is in place also to ensure that there is environmental compliance by businesses and companies. We've seen an increase now, even in litigation, not in Zambia, but around the world, where companies like Shell are being sued for oil spills, where we have companies that are producing single-use plastics that contain hazardous chemicals. Now individuals go before their courts and can sue and say this project has an impact on the environment, and this is how we consider it would impact human rights. So there is now a direct link that many have been able to create between corporate practices and the impact it could have on human rights. So this is an evolving space. And I think as we continue in our discussions, I'm happy to share materials. I'm happy to share the various bodies that exist for us to understand more about, for instance, sustainable financing, around corporate social responsibility or environmental social governance, because this is something that I think as lawyers we can't step away from now, because it feeds into human rights, which ultimately feed into constitutional laws and can find themselves actively engaging with our courts at national level, at continental level, or even through the UN system. So I would like to end here, but please let me know if you have any questions. I have highlighted some of the challenges that I see in the space, the impact that the corporate world has now on ensuring that they comply with environmental regulations, because this is the space that I am very familiar with, and happy to respond to any questions that you may have. As lawyers, there's many opportunities also for consultations and consultancies, I mean, in the sense that many organizations that are seeking to commence projects in our country would really like to understand the landscaping, especially around human rights as well as environmental compliance, because it's become an important factor for how companies can invest in a country or in a regional project. So I think that we have to continue to open our eyes and our ears to the evolution of the international treaties that are existing in relation to environmental protection and sustainability. Thanks, Maya. I'll leave it here. If we have any questions, happy to respond.
Thank you so much for sharing. I think that gives us a lot of context, especially because I think lawyers sometimes, when you ask, they don't even know exactly where human rights are applicable. So thank you for sharing, because that gives us something that we can take home with us or take to our offices with us immediately, right? So in terms of corporate accountability, with our business clients, in terms of the trade space, because when you talk about the trade space, then you're bringing in issues of unfair labor practices, things like that govern trade, taxes, all sorts of things. When you talk about environmental impact, particularly, we are in the wake of the acid spill in the Kafue River, which is a current issue that's affecting the Zambian people. And like you have rightly pointed out, by lawyers being more cognizant of human rights principles, it is our responsibility to be able to guide our clients and advise our clients to engage in human rights practices to avoid certain problems. So before we move on, I thought maybe on the issue of opportunities, whether you could share a bit more of your personal experience and get a bit more practical, because the bar generally is very corporate, and it becomes it's not really a straightforward path when it comes to engaging with human rights organizations and getting into the space, even when you speak of consultancies. I don't know whether it's possible for you to share just a bit more on your personal journey and how you were able to kind of define this path for yourself in terms of practical steps. I think that would be very helpful for many lawyers that are already passionate about human rights work, passionate about involving human rights work and engaging with mechanisms, but not really sure what the actionable steps are. What was your experience like? I think it would be helpful to get that from you.
Thanks, Maya. It's broad, but I'll try and summarize it. So generally, I think that part of the exposure I gained was through the Ministry of Justice. So the time that I worked at the Ministry of Justice, and I was in the Department of International Law. However, after I left, and now that I am consulting in the space, I recognize that what had happened with me was the first thing that I engaged with was state reporting. So there is a process called state party reporting, which takes place under the various international instruments. So I prepared the state party report under the International Covenant on Civil and Political Rights, International Convention on Civil and Political Rights. Now, when I had completed that, for those who enjoy research and writing, those who had academic experiences, the work that the UN usually seeks out from whether it is firms or individuals as consultants is very much research-based or advocacy-based. So some key organizations that I can immediately point out is the Organization for Human Rights, so the OHCHR. I will get the correct words. There's Amnesty International. There's the United Nations Human Rights Council. There is the International Federation for Human Rights. There is the International Committee of the Red Cross, so ICRC. They do work in the humanitarian space, so war crimes and what to do, how to apply human rights in times of conflict. These are all opportunities that if you Google the organization, you will see that they seek legal consultancy, for instance, to develop a paper, to develop an advisory opinion, to set out a case study as an example, and Save the Children International. So these are some that I'm mentioning, the ones that I've interacted with and how I found the opportunities, because some of them just need like 3 months of reports to be done or 3 months of opinions to be developed. And as you get into these spaces, there's always one recommendation coming up after the other. Yeah.
Right.
So I think that it's all a matter of if anyone is intending to be in that space, some of the skills I would encourage that we develop to be relevant in that space is research, writing, advocacy, which is how do you engage with countries? How do you get countries together to agree on a positioning? Because I did take part, for instance, in climate change negotiations. There's a lot of diplomacy that takes place there. So I did a short course at ZIDIS, it's Zambia Institute for Diplomacy Studies, just to understand how diplomacy works in the international space and how others interact, because beyond being a lawyer, there's a set of skills you have to have in diplomatic relations to be able to interact with many of these international organizations. So some of these are the key skills that I developed over time. I did a training in writing, I did a training in communications, I did a training in public speaking, just to be able to be, I'll use the word sellable to the international market. So being a lawyer is such a gift because you have a vast space of knowledge. most of these organizations, if you have a legal background, they are already ready to take you in because they know you've developed your writing skills, your research skills. So the biggest component now becomes international relations and diplomacy. Once you master that, I think, yes, you can get into any institution as a lawyer with that background. Yeah, you don't have to have specialized in international law. A master's is usually good and important, but trust me, when you have a legal background, they trust your writing skills, they trust your communication skills, they trust your research skills. When you study international relations, diplomacy, you are good to go.
Yeah, absolutely right. And it's interesting you speak about strength in research, because I think my journey was slightly different, because I don't consider myself very strong on research, though obviously competent. But just to add on, maybe to share my own experience, which speaks to what you're saying, what I got from you, which is essentially starting where you are, right? I was doing public interest litigation purely from law school and from Ziali. And that then led to consultancies regarding what was happening on the ground, because I found myself in many situations where there was critical stuff that was relevant to what was happening in the country, which I think is also something you've touched on, right? The work that you're doing should be relevant to a bigger conversation as opposed to being client specific only. So then I
Absolutely.
found myself in situations where there were certain rooms where there was only the client and the lawyer, right? And organizations like you've mentioned, like Amnesty, like Office of the High Commissioner for Human Rights, etc., had an interest in protecting the rights of my client at the time. But my client was most likely in prison. So they had no access to the client. So the next best person they could access was the lawyer. So then all of a sudden you start engaging. I found myself engaging more with human rights organizations on a consultancy basis, because they wanted to have people on the ground who actually know what's happening, which I think ties well to what you're talking about, being able to also put that information together in a way that's shareable. And then also work on your skills. I went to government schools. I was at DK, I was at UNZA. So I had to teach myself how to navigate international rooms, deal with foreigners. It's not something that came to me based off my academic background per se. So yeah, thank you for sharing that, because I think it gives us something we can take home. If I'm not mistaken, Laz has introduced a directive where lawyers must do at least one pro bono case per year.
Yes.
So that's a good entry point, I think, for lawyers to kind of seek out cases that speak to social issues, economic issues at a large scale, and kind of begin to work on their footprint and engagement with certain mechanisms. Thank you so much, Natasha. We're going to move to the next part of the webinar. You really already shared kind of like a nice historical context of the African Commission for Human and People's Rights. Yes, the ACHPR, the ICC, and the ICJ. But we're now going to hand over to Jakob for a more practical presentation on how lawyers can engage with these mechanisms. So Jakob has extensive experience and practical experience. He's a South African lawyer, but has worked throughout the continent, in Zambia as well. And yeah, I think he would be the perfect person to kind of share what engaging with these mechanisms looks like in practice. Jakob, over to you. Thanks.
Thank you, Mayor Mande, and thank you for this wonderful opportunity to speak to like-minded professionals, legal practitioners from the region. I don't think we get enough of this kind of opportunity to engage, especially on this kind of topic, because I think the regional legal framework on human rights and the institutions it has created has been underutilized. And it really is up to us as lawyers to creatively work towards the better and a more effective use of these institutions to provide real relief and protection to our clients. And I also want to thank Natasha for making my job a little bit easier. So in the 10 or so minutes I have, I just want to briefly take a meander through some of these institutions, just to make you aware of it. And I understand that there will be more opportunity later to delve a little bit deeper into the mandates, the opportunities that exist within these different institutions. So I will look at both the sub-regional African region and the international level. And when we look at the institutions or the tribunals created by these regional and international frameworks, I think it is important to point out that they have been created by a comprehensive framework of legal treaties on sub-regional, regional, and international level. So on the sub-regional level, through the South African Development Community, at a regional level, through the African Union, that has created legal frameworks of treaties, institutions, and mechanisms established by both the AU and SADC to promote and protect human rights on the continent. And essentially, it, to a large extent, it mirrors the kind of instruments created at a UN level, but it goes further and expands and reflecting African values while aligning with the universal and international human rights principles. So if I could just point out a number of these treaties at an African level, at the AU level. The foundational instrument is, of course, the 1981 African Charter on Human and People's Rights. Many refer to it as the Banjul Charter, and it's really the cornerstone that protects civil, political, as well as economic, social, and cultural rights. And it uniquely also brings within the legal framework the notions of people's rights, or the right to self-determination and development, which you won't really find in other international treaties. But then the AU has also adopted over many years a variety of thematic treaties: the African Charter on the Rights and Welfare of Children, the Protocol on the Rights of Women in Africa, the Charter on Democracy, Elections and Government, the rights of persons with disabilities, etc. And as Natasha pointed out, it has created mechanisms. I just briefly want to touch on the African Commission on Human and People's Rights, which is really the main supervisory organ of the African Charter of Human and People's Rights. And it's made up, I think, of 11 members who serve in their personal capacities, even though they are nominated through their governments and countries. And as the African Charter suggests, the core mandate of the African Commission is to promote human and people's rights and to ensure their protection, and through promotional work, setting standards, through the formulation of human rights-based principles, but also protective work, actual providing relief and protection through an individual and interstate complaints mechanism. And that's important for us to take note of, because I think of all the human rights organs that have been established around the continent, the African Commission is probably the most accessible, because Article 55 of the Charter allows for individuals and civil society organizations to lodge complaints against governments of member states. And as you know, Zambia is a state party to the African Charter, and in fact, it has been involved in a number of matters that have been brought to the Commission, and I can't recall the names now, but there was one that deals with the right to nationality. There was a case that dealt with the expulsion of foreign nationals, and it's certainly interesting to go and look up those cases. The African Commission also have, I think, after its establishment, it developed, like in the UN system, the notion of special mechanisms or special rapporteurs, who are basically independent experts, human rights experts, tasked with the powers to monitor, investigate, and advise on specific human rights issues across the African continent. And they are appointed by the African Commission in line with Article 45 of the Charter, and therefore their work complements and support the work of the Commission and its promotional and protective mandate. So what do? They focus on specific human rights situations or vulnerable groups. They undertake country visits to assess compliance and engage with governments and civil society and other stakeholders. They receive and act on information of alleged human rights violations. They advocate and raise awareness. And I mentioned these special rapporteurs because of its accessibility, because formal complaints and cases brought before the Commission and the courts can often take many years to complete, whereas the mandate of the special rapporteurs are a little bit more flexible, and it can at times be used in a manner that may resolve particular cases or complaints of human rights violations. And for Zambia, as I've mentioned, proactive engagements with the special rapporteurs can help strengthen domestic human rights protections. It can help influence law reform and raise international awareness. I know that Mayor Mande has got extensive experience.
Who has their mic on. I don't know whether we could kindly all mute our mics, just to not interfere with Jacob's signal. Sorry, Jacob, please go on.
No problem.
Please go
on. I was just saying, Mayor, that I know that you have engaged extensively both with the African Commission special rapporteurs as well as with the UN level special rapporteurs, and it would be interesting to hear your view on the effectiveness of working with them. Then, as Natasha pointed out, the African Court, which is an incredibly important institution, the African Court on Human and People's Rights, which came into operation 21 years ago following the adoption of the African Court Protocol. And as Natasha pointed out, there's been quite a move to merge the mandate of the Court of Justice and the Human Rights Court, Human and People's Rights. However, unfortunately, the African Court's rules on standing prohibits an individual or a non-governmental organization from litigating cases unless the state in question has ratified a declaration in terms of Article 34.6 of the Charter, which will, in those instances, allow individuals and civil society organizations the standing to bring such cases. Zambia, as I understand, has ratified the protocol establishing the court, but as for now has not made the declaration under 34.6 that would allow Zambian lawyers to present cases against Zambia. And I think for that reason, it may be something for the Law Society and civil society to consider and engage the government to consider maybe making their declaration that would allow non-state parties to bring matters before the African Court.
Hi, we have somebody, Mwila Hamusonde. Do you mind muting your mic? Thank you.
I have, Mayor, I've forgotten to mention that there are two sub-regional bodies in Southern Africa. I think I've briefly pointed out the SADC Tribunal. Now, in the Southern African Development Community, or SADC, a treaty was signed in 92 and again amended in 2001, which established a legal and an institutional framework for our sub-regional bloc. And the purpose of this treaty was to promote economic integration, peace, development among the 16 SADC states. And it also, of importance from a human rights perspective, created the SADC Tribunal. The tribunal is a judicial tribunal that allowed individuals and states to bring cases against member states. But I think most of you will recall that following the somewhat controversial case and the ruling in the Zimbabwean case, or the case against the Zimbabwean government brought by farmers who were evicted of their farms, the political fallout following that decision led to the SADC Tribunal being replaced with a tribunal with a more limited mandate that only allows state-to-state dispute. And as a result, I don't think any matter has been brought before the SADC Tribunal following that. So I think as a region, as lawyers, as representative bodies, I think it's high time that we engage our governments and the SADC bloc to reinstate the SADC Tribunal, because I do think that it can potentially provide a useful mechanism for communities, for groups to find protection, relief for violations of rights. Then just briefly to mention the COMESA Court of Justice. The COMESA Court of Justice is the judicial arm of the Common Market for Eastern and Southern Africa. It is not a well-known tribunal, at least not for me. I've never engaged with them. And as far as I know, they have not really dealt with a matter that dealt with human rights violations. And it is mostly dealing with trade disputes and violations of the COMESA regulations. But again, I think because it is technically possible for the COMESA Court of Justice to consider matters that relate to the rule of law and the support of democracy, that human rights matters can be brought before this court, and I think maybe something to consider. Okay, if we go on to the international level, Natasha pointed out two important institutions, the International Criminal Court and the International Court of Justice. These are two tribunals that are incredibly important, but have also become quite controversial in recent years over the type of cases that have been brought to it. And let's start with the ICC, the Criminal Court. In terms of its mandate, it's a permanent criminal tribunal based in the Netherlands. It was established in terms of the Rome Statute Treaty to prosecute individuals for the most serious crimes. That includes crimes of genocide, crimes against humanity, war crimes, as well as more recently, crimes of aggression under particular conditions. I think what is often forgotten is that the International Criminal Court does not act on its own, and that it acts in a complementary manner to support national jurisdictions and regional jurisdictions, and it will only intervene in cases when national courts are unable, or in certain instances unwilling, to genuinely prosecute crimes of that nature. And Zambia is a state party to their own statute. It has ratified the statute in 2002, and it also therefore has the jurisdiction over crimes committed on Zambian territory or by Zambian nationals. And as a result, Zambia has the obligation to cooperate with the International Criminal Court. That includes, for instance, to execute arrest warrants and to surrender suspects for whom arrest warrants have been issued. But as far as I know, Zambia has never been placed in the position to execute warrants of arrest, nor has it ever been investigated before the ICC. Then just briefly, the International Court of Justice it's an older institution than the ICC, and it has a different mandate compared to the ICC. The International Court of Justice, or so-called World Court, is the principal organ, judicial organ of the United Nations, and is also located in The Hague. It settles disputes between states and gives advisory opinions. So individuals and non-state parties cannot litigate before the ICJ. And it would typically hear matters that relate to border disputes, state responsibilities, violations of international treaties, the use of force and self-defense, as well as environmental and human rights law. And only states can bring cases, as I've mentioned, and the decisions are binding to parties, and states must consent to the court's jurisdiction. So I think it is, if we look at these two institutions, they are not very accessible. It becomes quite expensive for states as well as for individuals to bring matters to these courts. And again, I think it really requires a deeper thinking and engagement with lawyers within the region on how the ICJ and the ICC can be used to focus on human rights violations that are falling under its jurisdiction. Then just two brief notes. Outside the formal legal judicial systems of the UN, like with the African Union, the United Nations also provide for the appointment of independent human rights experts through the United Nations Human Rights Council to monitor, report, and advise on thematic or country-specific human rights issues. And it does so through these special mechanisms, through different mechanisms. So there you get the special rapporteurs, you have independent experts on a particular theme, as well as working groups. So for instance, you'll have a working group on arbitrary detention. And like the African counterparts, their main functions are to monitor and report on human rights globally, again, to conduct country visits, send urgent appeals and communications to governments, and to actively engage to explore the possibility of resolving human rights complaints without having those complaints needing to reach the courts. It also produced then regular reports to the Human Rights Council, and And so just to give you a few examples, and then I think you would all know many of these special rapporteurs. There's one on the freedom of expression, one on torture and other cruel, inhuman and degrading treatment, the rights of women and girls, climate change, as well as also the independence of judges and lawyers. And then there are special mandates that focus on specific countries, like we would have one on Eritrea, on Belarus, on Iran, Myanmar, etc. I read that Zambia, the Zambian government has hosted the United Nations Special Rapporteur on torture in 2010. So that is my brief overview of some of the important African and UN mechanisms. I think there is a lot more to unpack and discuss, because I think there are very good reasons why not more cases from our region and the continent have been brought before these mechanisms. And some relate to, stumbling blocks and limitations relating to access, having to exhaust domestic remedies before a matter can be elevated. Others relate to, I think, a lack of awareness and training of lawyers within the region on how to prepare matters of this nature to be presented or elevated to a sub-regional or regional and maybe UN level. And then cost, finding financial support to prepare cases and present, because often it does require quite a bit of resources to do so. So I apologize for spending too much time, but that is my quick introduction. Thank you.
Thank you, Jacob. You've actually even covered in your closing remarks something that I was going to ask. Thank you for sharing. I think this gives us a practical guide, and one of the major issues, like you pointed out, is accessibility. It's when it comes to unpacking all the instruments and the mechanisms that exist, we can't do that in a single webinar. So obviously, for the benefit of our participants, this is just the first of a series of webinars that we'll be having, and we'll be unpacking each commission and each tribunal individually and getting a bit more technical. And hopefully we can have Jacob and Natasha and a few other experts come on to kind of get into detail. But thank you for outlining generally the gist of what these tribunals do. And on the issue of accessibility, I think something that's important that you pointed out is the starting point is ensuring that the instrument that births this particular institution is ratified in your jurisdiction. So I wanted to ask, because you've already covered time and costs, expenses are a big issue, obviously. And like you rightly pointed out, you as a lawyer would have to be the one, or maybe let me ask my question first, because then it speaks to this. In terms of who can bring an action before these instruments, you were speaking of individuals and NGOs that are capable of litigating these matters. But I suspect that the majority of the participants on this webinar probably have law firms as opposed to NGOs. By individuals, do you mean a person specifically, or can a person in the capacity as a partner of a law firm bring an action? Maybe if you could just clarify that quickly for the participants.
Yeah, I think it depends on the type of case and the relevant tribunal that may be able to provide protection, support, and relief, because they have all been created in terms of different legal treaties, and some treaties automatically allow for individual complaints to be brought to a treaty monitoring body or a body of sorts to consider these matters. Others require an optional protocol or a treaty to be ratified by the state party. And Yeah, so and many of these tribunals and treaty monitoring bodies have overlapping mandates. So sometimes you are not limited to presenting a matter before one body alone. There are maybe more than one available. So it is useful to understand the opportunities that may exist, so that one could look for the most relevant body, and then also to look at the easiest and the quickest way to get the matter presented before the relevant body. Unfortunately, some of the issue of implementation of decisions by courts and quasi-judicial bodies on the continent, as well as internationally, is a big problem. And because unlike national courts that have a whole enforcement mechanism through the state apparatus, the police, and whatever, the international bodies do not have the luxury of those implementation mechanisms. So often you would get a positive result, but lack the ability to compel the state to implement those. Thank you.
Right. Thanks. Which also I think also speaks to the issue of costs, right? Something that I think is relevant to what you had outlined, how things like this are very expensive, because for you to be able to take a matter before an international tribunal, there are travel costs, there are administrative costs, it's expensive. Do you know off the top of your head, maybe let me ask this, any mechanisms that are available to kind of support such type of work? Because usually, say in traditional practice, you can have a client that can't afford to pay legal fees, for example, but you can be entitled to recovering your legal fees through costs. How does that work, say, at an international level? Are there already institutions that exist? And this is, I guess I'm also asking this for my own benefit, because I've never really thought of it that way. What does resource mobilization look like generally in terms of trying to achieve this?
So because of the long delays in getting cases adjudicated before regional and international tribunals, it is often better to find resources and work with institutions and organizations that may pursue the same kind of advocacy objectives that you are pursuing through your individual case as a lawyer in Zambia representing a client or a community or whatever the case may be. And I mention this because there is funding through donor organizations like, for instance, the Open Society or the Ford Foundation or and others who are interested in promoting and supporting cases of strategic value to be brought before these bodies. And I think it is useful to for the Law Society or for associations representing lawyers to proactively engage with these civil society organizations on a national but also a regional level, and the donor organizations, just to make them aware of the need for support for Zambian lawyers and other lawyers in the region to do so. They are also, I think it is important for us to move beyond our national borders, and we are increasingly seeing lawyers collaborating within Southern Africa on litigating human rights matters, and sometimes you may have the case, another organization in a different part of the region are interested in supporting the same issue, but may have resources in doing so. And so there may also be a possibility. But I think, Maya, through your extensive work in the region, I think it may be an issue to explore in future conversations.
Thank you. And you've pointed out something that's very important when it comes to kind of navigating some of these issues. It's kind of network building and solidarity. You spoke a lot about special rapporteurs, and I think maybe for the benefit of some of our panelists, maybe I'll quickly explain what a special rapporteur is. Essentially, a special rapporteur is an expert, an independent expert that is appointed by the United Nations Human Rights Council to monitor and report on either a specific country or a thematic issue. So like Jakob had pointed out, you have a special rapporteur on the freedom of association and assembly. You have an SR on protection of human rights defenders. Lawyers fall under that because as long as you are litigating a matter, particularly pro bono, you do qualify to be a human rights defender. There's an SR on the independence of judges and jurists, and there's so many. And Zambia doesn't have a country-specific SR, and I think it's because in comparison to other parts of the continent and the world, it's relatively peaceful. But we do have many other SRs. There was another SR that was in the country, I think, earlier this year. I think it's on the freedom of press. I'm not sure the exact mandate, but yeah, one thing that comes out in terms of engaging with these officers is the weakness when it comes to enforcing certain things. So this is a list of experience. Yeah, SRs and their officers are really good for building awareness on an issue and kind of getting solidarity in terms of international solidarity, finding resources and engaging more stakeholders. But I think there's still a big gap in terms of how that translates to change on the ground, because you find that there's lack of information, there's lack of support locally. So even as lawyers, I think that are working in this space, we kind of do so in silos. So it's very difficult to kind of connect, especially on a country level. I would say I'm Zambian. Most of the lawyers that I engage with are Africans, but not necessarily Zambians. So I guess I'm speaking for myself as well. There's need for us to kind of strengthen our network internally for resource mobilization, sharing of ideas. And I think that also carries more momentum when you start engaging with, say, the Office of the Special Rapporteur or these other UN mechanisms, when you're able to demonstrate that at a local level, there's enough traction from competent people who understand how to litigate the matter, how it relates to social and economic issues, etc., etc. So I think that really kind of shares everything. I don't know whether we have any questions before we close off this webinar. This brings us to the close of this webinar, and we hope to have another one shortly. We will be discussing the United Nations a bit more extensively, the International Court of Justice, the COMESA Tribunal for those lawyers that are working in trade. So yeah, do we have any questions before we close? Going once, going twice, going 3 times. Thank you everyone for joining us, and we hope to see you on the next webinar.
Thank you. Bye-bye.
Bye-bye.